Yes, ma'am.
I served him, well, I didn't actually served him. We filed a return with the court, which has the date of service. We contacted him since he served, to make sure we had proper contact numbers. He did have a conflict in June, one of the weeks in June, he had a conflict. He told us about it, but we've not heard about any other conflicts since that day.
Has there been any other contact since then, as far as you know?
As far as, I've worked on the main portion of the case, so I didn't contact him anymore since that day because I was not instructed to call him. As far as the mitigation, I can't say.
He was served where?
In Atlanta, Georgia, if I can get the return of service, I can give you the information. The address is, that we show is on record initially was 1414 Glenover Circle, Marietta. We learned that was a bad address. We later learned that he was at 922 Walker Avenue, Atlanta, Georgia, and that's where he was served at. About what kind of time?
Nothing has been done, as far as you know, since that time.
As it applies to mitigation, I don't know what contact information given to the mitigation person.
Anything else, Mr. Lewis, on that issue?
They said that some witnesses, what I said, a witness supposed to come here at 9, one of the witnesses. Said we all over the place this morning, you know. I showed them like it. But, as far as that job, I can't do nothing to tell you what I can tell you, but I can told you on that guy. They just said they got one of the other witnesses they're gonna be here at 9, but I guess I can't show it off Mr. Smith, you know, give us something. But Judge, I don't know who out there or how they doing it.
Are you ready then to call Mr. Smith?
No, this is what I want to do for the record, because apparently a great number of my witnesses is not here right now. I'm going to tell you about that, you know. It's very disturbing, Judge. You know, I like to say this for the record. I've been in Oklahoma jail. I done told the people who you appointed me casework that was paid, who I want, you know, and what I want for. Some strange reason that I can't understand, they're not here this moment. You know, I'm at this Oklahoma jail. You know, as I stated, my standby counsel when he can come to the jail to see me and talk to me and help me prepare. At the jail, on witness night here, I have a number of witnesses that I was looking for to call today, and they are not here at this present time. You know, I got Mr. Scott there, and Ms. Michelle, and they over in the Oklahoma jail. Maybe we can get Ms. Sullivan to call them. They're not too far, but I'm expecting to get them in here. We got another one says she comes at 9. My mom here. Miss Aileen Bishop Howard, she's not here. Jerry Burton, I want to talk to you about that while on that matter. As for Miss Aileen Bishop Howard, she can be rebuttal. I think she's rebuttal to the victim impact given by Tony Howard and Jerry Johnson. Tony Howard said yesterday in the victim impact statement that I will also all get fussed at my family member for no reason at all. When before, this would have never happened. This is a family member, stepmom. She said he beat her. There will be a direct rebuttal to what he stated to the jury yesterday.
Well, I don't know that I need to know that, so have you subpoenaed,
Yeah.
Ms. Eileen Bishop Howard? Okay.
And oh, I'm sorry.
So she's not here?
Yeah, she's not here at this moment.
And have you know, has there been any contact or any indication that she's gonna be here?
Judge.
I can only try to do something if you tell me what you're asking me to do.
Basically, my investigators, they contacted her last night to be here. As far as Jeremy Burton and Jesse Matt, I don't know them about that, Judge. Did somebody talk to Mr. Burton and Mr. Matt? Okay, can somebody please find and tell them? You know, Miss Aileen Bishop Howard, Judge, Jeremy Burton and Jesse Matt, you know, things that we couldn't get in the first time at the first phase. I think they're relevant as well.
You don't have to tell me that.
Okay.
I mean, at this point, I mean, we just need to, if you subpoenaed them and they're not here, have your investigator follow up and see what you can do about getting them here. If you're asking for the court's assistance in that, let me know that.
Yeah, I guess in my last result.
Okay.
So she just informed me Ms. Howard's on the way. Mr. Burton he's here. Mr. Jesse Mack, he's here. My former attorney James Smith, he's here. Ron McGee here. My mom's here. Miss Anjanette Grant says she on her way. Miss Janae Burke's here. Dr. Carrie Baker Smith, she's here. So we need to get Mr. Scott Bear and Michelle down here. The only way. I guess we got another role.
All right.
You know, do something.
So you're ready then?
I guess I just go off the fly just to get us started. Or this, I forgot this. I got to bring this to your attention before we start. I'm sorry. I'd like to make some things known for the record. I would like to raise a matter related to the testimony yesterday pertaining to the victim impact testimony. As you recall, there was victim impact evidence regarding financial difficulties for both families, if you call it. I have done some investigation and I have found out that both families received substantial financial assistance from various sources. Before I can decide what, if anything, I want to present, before I can decide whether I want to present that to the jury or not, I need full disclosure of the detail of each and every financial benefit that each family has received from many sources. Because the state affirmatively presented this misleading evidence, they should be required to make a thorough inquiry into this matter and advise me of all the details, because I cannot receive a fair trial without full disclosure. Judge, I don't want to disrespect nobody, but I heard family member, not calling no name, there's different family member, as you heard, and the record reflect financial difficulties. And not one time they say anything about the substantial benefit they have received. And what I did, Judge, was I did a little investigation. I brought some evidence of the financial benefits that they have received. I can retrieve that right fast. Did I leave anything back there? A folder? I think I might have a folder. I think I might have left it back on the table. I might have possibly. I'm kind of rushing, Judge. I'm sorry. I got that. What this is, Judge, I got different newspaper articles here. This one was wrote on Monday, May 23rd, 2011. It says, Blueprint Ride raised the fund in spirit for those touched by police shootings. I think what they raised, $15,080. It says some 500 cyclists and 800 riders total participated in the ride, and $15,080 was raised for the Christian and Howard families. That was told to the jury yesterday. And then here, this is Atlanta CBS newspaper. It was posted April 10, 2011. And it says that another $15,000, but it says 100 turned out for injured ads and officer fundraisers. So additional $15,000 were raised. Then I see here, ads in newspaper Friday, August 26, 2011, $85,000 was raised for the Christian family. It says that the theater concert raised $85,000 for the Christian family. This wasn't told to the jury yesterday. Then here, slain officer family giving $60,000 in bonds. It says something like Marines. This was the Marines gave Officer Christian kids or somebody $60,000 in bond for them to go to college or something. That went missing yesterday. Also, what is this? Is October 3rd, 2011. Building community band together to make Widow's Dream home a reality. They had built a brand new home for Officer Christian and his family. That wasn't missing yesterday. Blueprint for Dreaming Home and Vision Home. And I feel like the state purposely misled the jury with financial hardship. I understand it's hard on. I'm not here to be disrespectful to nobody. But let's not mislead just to get me to death sentence.
Let me hear from Mr. Baldwin. You want to be heard.
Where that certainly had to cross-examine them about that information. respect to the family, that's not, didn't impact testimony, we say, yeah, you know, that's a chance of what you did. You had not seen the wrong family, and that's what you did. You're not ready to do that.
Yeah, I didn't cross-examine them on that because I had to go back and investigate. I had to listen further. You know, I was trying to be respectful because I know it hard on them by not saying nothing.
I understand, but that would have been your opportunity, whether you were aware of it or chose to do it or not. So your objection is noted, or?
Well, how about this? What?
So it indicate how we investigated, what is he talking about, he has, I don't know what he says he has, and, you know, he's reading off of, and all of a sudden, like, available beforehand. I think, you know, he investigated that, I don't know, he was in the county jail, so I don't know what he's playing about his investigator, so I don't know what he investigated yesterday, what he's reading off of, and that's.
Now, these just newspaper articles. Judge, he have a duty to give me all this, because how can I have a thorough civil cross-examination? I don't even have all the information that he's supposed to give to me. So how can I cross-examine them when he's supposed to give it to me? He knew all about the financial benefit they received long before we got to court. It's on him to disclose that and give it to me. That's just reciprocal discovery obligations that he has, that he didn't do to him. And his guard officer said that he done it, and I had to go look in the newspaper, there's some old newspaper article to find it. What made me look at it, because I'm like, wow, I thought, let me go see the newspaper, because I had heard about a lot of stuff, but I just didn't get into it. So I went through a newspaper, I'm like, well, Mr. Malton didn't disclose this to me, so if I knew about it, I'm pretty sure it's more in depth than that. He the one has a duty to give it to me, because I can't have a thorough cross-examination. He don't reveal what's really going on.
Well, I looked by your own motion, you indicated it was a newspaper, you looked at newspaper articles that have been published years ago, so your motion's denied.
Okay, I would also like to renew my objection on the excessive and highly prejudicial victim impact presented yesterday. And I think it is important that the record accurately reflect that a number or juror was visibly crying yesterday. They was crying yesterday off all these excessive pictures. They was crying. That's why they done it. To invoke passion. Let's convict them all passion. Let's show pictures that don't even have no relevance to March 22nd, 2011. I bet about 100 pictures.
This is the same motion you made yesterday.
But I'm talking about the crying. I'm trying to complete it. We didn't get there about the crying. I'm pretty sure you saw him over there crying yourself. The record should also reflect that several witnesses were crying during their testimony during the victim impact statement yesterday. I feel that the totality of these very emotional circumstances were unfairly inflammatory and prejudicial, and just the type of situation that the victim impact cannot constitutionally create. This whole trial I've been enduring prejudicial things just to try to get the whole thing to closure. But when it comes to my life, I think somebody should have some integrity about themselves. I shouldn't have to tell you when you know better than me. So I want the record to reflect that there's a number of jurors was crying, as a number of witnesses yesterday was crying. And I want, again, for the record, say I move for a mistrial on that matter, just for the record purpose. So on the appeal, somebody can look at it, and then I might need this to be overturned, because I feel like, you know, you got people crying like that there, that ain't good. So, that's where I'm at on that. I'm gonna respect all the ruling as I have been, but, and then second thing, Judge, before I get into the case, do you think there's any way that you can give me a few minutes with these investigators and talk to them about what the witnesses, you know, like the prosecutor go out there and do it, get ready for his witnesses? Can I have at least about 10 minutes to do that, then so I can get into it? Because I hadn't talked to nobody, I'm just really going off the fly.
Well, I'm not sure what happened yesterday when we left. I don't want you to tell me, but that's what that was about.
They didn't talk to them. I don't need them for 10 minutes. I see they've been doing it 100-something with. They have.
I'm gonna give you the 10 minutes, but, let me also, deny your motion for mistrial.
Okay.
Is there anything else? Okay. We'll be ready to.
If I may, I wanted to, it's on my record, if I can.
All right.
I'm serving him a copy of the recording of the phone call we had last night with one of his witnesses, I believe, could, to make sure he had that as we had, and if he is going to call as we could, she's been in the courtroom the whole time. Once she was released, he was going to call her, you know, the sequestration applies as well, and should have applied, because this junkie did call her at that time. And further, in order to Alice Howard, before she testified, I would have a motion about her testimony, for being able to talk about those matters in regard to Howard, who excluded matters that he was not even aware of in any way, like that. So I would certainly exclude all that, we'd like to hear on that before she testifies, before she's called to testify. Complained about her, apparently she's coming up here. He'd actually released her from this, after she testified, she was released. If I recall correctly, before she testified. So, in any event, those matters.
Judge, that's guilt innocent phase and sentencing phase, two different things.
We'll take it up when they're called.
All right.
10 minutes.